reject patents that should probably be accepted. And then finally, the transformation prong is vague, because if you transform data that is related to something that's physical, it's patentable, but if you transform data that's related to something that's not physical, then it's not patentable. Well, tell me, what about data about money? I've got dollar bills in my pocket, it's undoubtedly physical. Now the reality is we are not calculating stacks of dollar bills when we're doing these complex financial transactions, but how are we supposed to decide whether that's physical? This was a problematic ruling, and so the Supreme Court took cert. And the Supreme Court granted, the Supreme Court nixed the patent. If you went to oral argument, and even if you didn't, everybody knew that Bilski was not going to get his patent. It was a terrible patent. It was an awful, awful claim. Because it's not new, it's obvious, and there were many other technical problems with it. The real question of the Supreme Court then was, how are we going to get rid of this patent? Are we going to get rid of all business methods? Are we going to come up with a narrow decision? And it turns out the court was split. 4 justices nixed the patent, saying this is an abstract idea. The other 5 agreed. 4 justices said, you know what, we can come up with some lines to, some tests to come up with finding out whether something is abstract. 4 of the other justices agreed and said that line is get rid of all business methods, and 1 justice, Justice Scalia, said I don't agree with either of you. I'm just going to stick with the abstract ideas and nothing more. And so here's how the ruling broke down. A 5-court majority said Bilski is unpatentable because abstract ideas are unpatentable. The other 4 justices who concurred in the judgment agreed with that. It was 9-0. Abstract ideas are unpatentable. The court also said that the addition of the pricing formula or limiting it to energy data, etc., weather data for energy commodities, was token post-solution activity or insignificant post-solution activity. In other words, they said, you know what, that doesn't make it non-abstract. We're not going to tell you why. 4 of the judges would have banned all business methods altogether. All of the judges said that the machine or transformation test is a clue to patentability. Is a clue. They don't tell us what the clue is. So that leads now to what's happened since. These are some of the issues for the future to think about. Number 1, and I just published a Supreme Court review article in the Cato Supreme Court Review called Forward to the Past. Basically, the court has done a rewind. The joke I like to use, I didn't put it in my article because people said it was too glib. If you ever watched the old show Dallas, they killed off Bobby one season, and then they went a whole season without Bobby, and they decided that it was a terrible show without it. That or Patrick Duffy just couldn't get another job. And at the beginning of the season, after the season he was gone, his wife, Victoria Principal, wakes up, sees somebody in the shower, and out steps Bobby, and lo and behold, the entire last year was a dream. And they just picked up where they left off the year before. They literally wrote off the whole season. Which was good because everybody else killed off and come back and whatever else they wanted. That is basically what's happened here. The court has said, let's do a rewind. Let's now ignore the last 30 years of patentable subject matter jurisprudence built up in the Federal Circuit and just say, you know what, that didn't work for us. We don't know what does work, but we know that didn't work. So let's start over. So we're moving forward to the past. And the questions that will have to be answered are, number 1, what is an abstract idea? And I'm working on an article right now with 3 other professors. We did an amicus brief in this case. And we're going to try and answer that question. And let me tell you, it is hard. We can't agree. We're trying to come up with something, or I'll tell you a little bit more about that in a minute. The second question, what is insignificant post-solution activity? When is it okay to ignore the machine? And then third, and a question that I've asked, but that has been rejected by the court, unfortunately, is why not just drop all these restrictions? They don't work. Isn't there a better way to rein in bad patents? I think there is. The court says, you know what? We're not going to patent abstract ideas, and that's just the way it is. So, what are some of the implications? Number one, the courts are falling back on the machine or transformation test. Even though the Supreme Court said this is not the specific test, lower courts just don't know what to do, so they're doing what the Federal Circuit said before, and they're using the machine or transformation test as a strong presumption. I don't have time to go into it now, but it's leading to some odd decisions. Number two, it's too soon to tell whether all this is going to have an effect on investment in research and development, and that's really why we have a patent system. That's the question we should be asking, and unfortunately, we just don't know yet. It's possible that having all of this vagueness is good, because at least software is still patentable, so people still invest, and so they'll take their shot. Or maybe the vagueness is bad because it creates uncertainty and people won't invest where it's uncertain. Or maybe it'll have no effect at all. The people who believe that that companies are going to write software whether or not it's patentable, well then this is just a sideshow, because people will do that anyway. And finally, I want to propose a better way to think about abstract ideas, and this is the subject of the article I just mentioned. And I think that better way is to think about abstract ideas as a way to control the claim scope. Basically, when an inventor claims something that we say is just too broad, when we say to ourselves, there is no way that they invented all that, or that they could have invented it, or we say there is no way that they should be allowed to have claimed to have invented all that because it would close off the field, then we don't allow it. So, for example, if we looked at back at Gottschalk versus Benson, the court was really concerned with saying this conversion thing, this conversion algorithm, which existed before and could be done on paper, is so important that we don't want to close off doing it on the computer. And hedging is so well known and so well used, we are just not going to let you claim all hedging. And so I don't know how we're going to figure out where the proper claim scope is. We're still working on that question. But I think if we think of it that way, prior cases tend to make more sense and are a little more applicable. So with that, I will turn it over to my debate opposition partner, hopefully agree or...
Ladies and gentlemen, Professor Risch, I do agree with a lot of what we just heard, but I think there are some other things that we need to look at. And in fact, as I heard Professor Risch say, the decision in Bilski isn't totally bad. And actually, to be truthful with you, that's the biggest problem with the Bilski decision. The Bilski decision, I talked about it back in May at a State Bar Association convention. And what I told the people there is, you'd better get ready to write to your legislators. Because if Bilski comes down bad, if they wipe out business method patents, you're going to need to start lobbying Congress. Okay? One of the things, and I think it's really important to point out to the Federalist Society, is the basic principles we're talking about here are very much established in Article 1, Section 1, Clause, or Article 1, Section 8, Clause 8 of the Constitution, where we set up our patent and copyright system. And Congress acted almost immediately when they first sat to pass the copyright law and the patent law because they felt it was important. In fact, it was important enough that the first patent system that we had 3 examiners, and Thomas Jefferson was the lead examiner as Secretary of State. Not that the Secretary of State has a logical job of examining patents, but he wanted to do the job. And the language that we're looking at in Bilski, Section 101 of Title 35, is almost word for word what we had in 1790. In fact, the only major change they made in 1952, and in fact that is the last time we really modified Section 101, was we changed the word art to process. And then when we defined process, we said that process includes art. But, you know, process, a business method is clearly a process. And in fact, if we look at what the en banc decision in Bilski told us, and in fact, if we look at what the Supreme Court ultimately told us, they didn't really tell us anything new. The machine or transformation test that the court in Bilski said you have to use, you know, we can find that test. It goes back to the Benson case that Professor Risch was telling us about. The fact that abstract ideas are not patentable goes back to Diamond versus Deere, at least. And I mean, it's in the code. So it's covered, but as in Deere and as in this case, the court doesn't tell us what an abstract idea is. I think the thing that was missing in this case is my hero of intellectual property in the Supreme Court over the last 25 years before she left the court, and that was Sandra Day O'Connor. Because Sandra Day O'Connor would have, you know, looked at this, and I think she would have seen that over in the copyright code, we have section 102B, and 102B is sort of the equivalent of 101 in the patent code. But what it says, it's very clearly worded by Congress to be open-ended. It says that it includes these things. And it certainly leaves it open to being modified to include new things that come along. And I think that certainly that's where we should be with Section 101. That's the approach that the Supreme Court should have taken. There are good things that were not in the opinion that were in the oral arguments. Judge Ginsburg was raising arguments to say, you know, don't most countries not allow software patents because they're not part of the technological arts? And most countries require that things be aligned with the technological arts. And, you know, had we taken that, had the court taken that position, it would have been quite wrong, because, you know, we've got a constitutional requirement that sets out the limits of our patent system, and it really doesn't matter what's going on in other countries. You know, we should be looking at what's going on here. Now, I would like to correct Professor Risch just slightly on one issue, because in talking about fluke, he tells us that that's a catalytic converter. It's not a catalytic converter like you would use on your car, and I think that was the implication. What this is a hydrocarbon refinery. It's basically an oil refinery that you're doing these process limits in. But the problem even there, and the problem with that case, is that in Parker versus Fluke, it really is just a control algorithm that is being dealt with there. And it's really, you know, there really is no requirement that it actually takes place in a refinery or any other kind of chemical plant. In fact, that's the thing I think we need to look at. And one of the reasons why I think it was somewhat unfortunate that we had Justice Stevens on the court still when this case was decided. And that is that Justice Stevens wrote the opinion in Parker versus Fluke. And in Parker versus Fluke, he got Judge Risch from the Federal Circuit. Actually, at that time it was the Court of Customs and Patent Appeals. Judge Risch, who wrote most of the 1952 Patent Act, got quite upset at what he read from the Supreme Court, and in a case called In Re